Hello, everyone, and welcome to Live with Lisa. We're streaming live on LinkedIn and Facebook today, simulcast. Woohoo! So drop us a hi in the comments and let us know maybe even where you're joining us from in the chat so that we can, I know that you can hear me okay. It's just a good way to kind of get a pulse check out there. Today, my guest host is my longtime friend and attorney, Steven Thrasher. Steven has a double major in electrical engineering and finance and received his JD and, get this, MBA from the prestigious Baylor University. I've known Steven for over 20 years, and I love him not only because of his incredible knowledge, but also his very unique ability to translate extremely complex information when you're talking about intellectual property into practical real world business strategies for intellectual property. And today I'm going to share, or he's going to share, I'm going to share a little bit too, but he's going to share some of his awesome tips and tricks for protecting your intellectual property. And this is all things. So if you want to talk about trademarks, copyrights, patents, nothing is off limits here. In addition to licensing, whatever is on your mind, feel free to drop those questions in the chat. We will take them in the order that they come in. Steven, thank you so much for being here once again with me today.
Thank you, Lisa. It's a pleasure to be here and a joy to be with you here, particularly in the new year.
We always have a lot of fun. In fact, Steven and I, one quick, really short story. When I was working on, I don't even know what invention I was working on at the time, but Steven and I happened to bump into each other. In fact, I think it might have even been when we first met, the Intellectual Property Association, right?
Down in Houston.
Yeah, in Houston. And we went to a Village Inn or one of those types of places and sat up until, I don't know if it was like 1 a.m, fleshing out an idea that I had for youcanbookit.com was the idea. And the concept, this was, of course, early days of the internet and dating myself, not that it really matters, I'm sure you can tell. But the concept was to be able to allow salons and restaurants to have a system on their website so that people can book their time. Sounds silly now, but it was so progressive back then. You remember that night?
Oh, gosh, yeah.
That was
gosh, yeah. That was one of the quirks of the patent office, particularly with software, is that different administrative regimes either become very pro software patent applications or very anti software patent applications, especially back then. And we just would get whiplash because what would be patentable, during 1 year, it would change on a dime.
Well, because everyone was still figuring it out.
Yeah. And some decisions came out about almost 8 years ago now, and it started to kind of be more steady state, but you still get some of these really weird quirks, particularly with district court decisions that are sometimes really pro software patent applications and sometimes really anti software patent applications, which is weird because the big tech companies are filing patent applications like crazy on their software tech.
Yeah, and it's still kind of changing, but it seems like they've kind of found at least the framework for a formula to start with, but it's still unpredictable, right?
It's much more difficult to predict than I wish it were.
So do we. We wish the same, right?
And 20 years ago, I guess when we met, as a patent attorney, I could get a search result back and I would have a strong sense of whether something would be patentable or not. And now you got to hedge your bets. It's hard to get a real comfortable feel about almost anything.
That's got to be scary because your insurance is on the line. If you're giving an opinion, a patentability formal opinion on something, then your butt's on the line, right? You don't get that right?
Yeah, and that's why if you get a opinion letter from a lawyer, you're going to see lots of wiggle language in there and what we call boilerplate, form paragraphs that say things like, of course, this is based on the limited things we found. If you want to pay us more money to do more searching, we'll take a look a little bit longer. It's just the environment we live in today.
It is. It is. I see you all checking in. Thank you so much. It's good to know that you're out there all over the world. So good to have you. This is being recorded. If you're just joining us, to let you know, and you want to come back, if you have to drop off for any reason and don't catch the entire program today, you can come back and check this out either on my feed on Facebook or LinkedIn. And below the video, even after when the recording is there, you can still drop your questions in the comments below, and we will do our best to get those questions answered for you. At any time, feel free to start dropping your questions in. I see Chep has dropped one already. Before I dive into those, Steven, I have a question for you. I'm getting a lot of, this has always kind of been a common question, but more recently I have noticed it's happening more frequently, and maybe that's just because of the number of people that I talk to. Everyone, as a general best practice, independent inventors are being taught to go get a provisional application and then use that 12 months to finish the idea and try and get it licensed so you can use other people's money to fund your utility application. The question that comes up is, if you don't get it done, and most often, let's be honest, a license doesn't happen that fast. So if it's not done in those 12 months to fund, what is the best, in your opinion, best business strategy? And I never ask attorneys this, folks, just so you know, but this is going to his MBA brain now. What is the best business strategy? Is it to file another PPA, or is it to go ahead and move forward with your utility application? What's your opinion?
I'm going to give you kind of a couple of different tracks you can think about. This is a question I get all the time. And in fact, I got the question from someone yesterday. So it's real timely.
Yeah.
When a provisional is expiring, what is really expiring is the right to use that year that you've had as priority to claim, your filing date for your utility application back to it. So if your provisional expires, you've lost that look back right. The consequence of that is that if your provisional expires and you've done something in the prior year that would become something called a statutory bar event, then you actually have a very rapid clock ticking on filing either the next provisional or the next utility application. The more scary part is if someone else has done something in the last year that makes the idea public. Then if you let your provisional go without filing a utility application, then that action by somebody else will invalidate your ability to file an application going forward. So something that you will see at some trade shows are companies walking around looking at competitor booths, looking for new innovations that they see. And even for something that's patent pending, at the end of the day, they'll go back and they'll blog about the thing that they saw their competitor working on. And so if their competitor only had a provisional and then they let it lapse without filing a utility, let's say they file another provisional even before it expires, but after the trade show, that publication by your competitor can be used against you for trying to get your own patent approved. So I'm not sure if that's a complicated scenario to follow.
No, that makes perfect. So what you're saying is you start the clock when you publicly disclose your invention.
Mm-hmm.
If you're without a patent, you start the clock. It's called public disclosure. And you have 12 months to obtain or file for intellectual property, in this case, patents.
That's right.
And if you don't file within those 12 months, it just becomes public domain. Anyone can make it, right?
That's right. Yeah, that's based on what you do.
Right. So then if I filed a provisional before or after that trade show, doesn't matter. Mm-hmm. And someone, because it was publicly disclosed that day, regardless of my provisional, if I let that provisional lapse, then because it's been publicly disclosed, even just by virtue of doing it at a trade show, essentially you're publicly disclosing it, whether someone wrote about it. But it would be easy for the patent office to find and easy for someone to argue and ultimately litigate you out of your patent rights.
Well, yes? Yeah. And here's the mistake people make. They think that trade show was my first disclosure. I have another year.
Right.
Well, that competitor's publication just turned letting your provisional go into a death penalty.
That's okay. So if that happens at the end of the 12 months and it's time to file either a new provisional or a utility application. And I know the answer, but just for the sake of our audience, the difference between filing a new provisional is you lose the original
You
filing
lose that 1 year of priority.
versus going ahead and filing the utility.
You maintain that 1 year of priority. So the best practice, it's not the cheapest or the most economical necessarily, but the best practice is to go ahead, file a utility on what you have. And then once you have a utility patent application pending, there are additional ways you can add subject matter to what you filed in the future in other patent applications, sometimes called continuation or continuation in part applications. If you're adding matter, they're technically continuation in part applications. But just letting that priority date go can hurt you.
Right.
Technically, I've seen inventors do what's called chaining provisionals. So if you have an invention that's in a really obscure market and you're just confident no disclosures have been made, if you're confident that it's, that invention has not been offered for sale, then if you let the provisional expire and just file another one, you might be okay. You're still taking a risk. And I call that chaining provisionals. And of course, you obviously get the benefit of being able to say patent pending. But the risk is when you let that provisional go, you're letting your time priority go as well.
And is submitting to a company with a PPA considered public disclosure?
Okay, so yeah, there's two parts to it, right? So with an NDA, it's not considered a public disclosure by you. It might be considered an offer to sell. And so depending on how that letter is worded, and this is why you want to go through a professional like Lisa, if you can couch what you're presenting as the exploration of an opportunity that could lead to an offer to sell, then you've not triggered some of the statutes. But if you say to a company that you want to license to, hey, this is yours, $100,000, that's an offer to sell. And that triggers your 1 year deadline, but it's not technically a public disclosure. That there's a little nuance in
an offer to sell. Offer to sell has a clock on it, just like public disclosure does, is what you're saying.
That's right. That's right.
12 months.
And so that's why you can make a private disclosure in anticipation of making an offer to sell. And that's different from making an offer to sell.
Okay, my last question, and then we'll dive into the questions in the chat. So the most common, again, practice among independent inventors out there being taught, this is not something I agree with, but that's for business strategy purposes. They will take the same PPA, run the risk of just filing a new PPA, literally just refiling the same paperwork. They understand that they're losing those 12 months. They may not be considering the offer to sell or the public disclosure as a reason for their patent potentially being litigated later. So that's off the table. They're just doing it over and over. Is that okay with the USPTO?
Well, it's not okay with me.
With the USPTO, is it allowed?
Yeah, so technically it's a quote unquote allowed, but you got to ask, what are you paying for with those additional filings? Mm-hmm. And what will happen if you actually start making money in the future? There are so many tools for defense attorneys to use today to invalidate valid patents and to defend pirates who are stealing stuff left and right and know they're stealing stuff left and right and have business models made around stealing stuff that you can't afford to risk being wrong. Because if you have money, if your invention is actually going to make money, and why are you chasing it if it's not? At the point you make money, you will get knocked off. And when you get knocked off, you're going to have to take some kind of legal action against someone. And then their attorneys will start trying to invalidate your patent, and they'll look for every avenue they can to do it. And when you have multiple filings in the patent office, they're going to find out at some point. And when they do, they're just going to start digging for those
Disclosure.
what we call, statutory bar dates.
Clocks. Yeah, they're going to look for the
Yeah.
clock. And where's the ticking time bomb that they can blow up in your face? Yeah.
Yep.
I just for the sake of wordsmithing this, you said they will knock you off. I just don't want our especially paranoid inventors to get too far. Don't embellish that. It doesn't necessarily. I've never been technically knocked off. I've had people innovate around me and do a better job of it and win at the game. And I hate myself for it, not them, for not thinking through the idea well enough to consider those opportunities or those optional.
Yes, saying you will get knocked off, by that I don't mean they're just going to steal your design and run with it per se. Right. Sometimes they will, but usually what they try to do is something called a design around.
Yeah.
And you want to make it as hard as possible for them to do a design around. Again, there are businesses, and I won't drop their name publicly because I don't want to get sued. These guys are highly litigious, but their business model is to find things that are selling well on Amazon, on Etsy, on any of these other large sites, and then try to find a way to make the product cheaper and do a better job marketing it.
Right on. Okay, Chet, you're up. I know this is a big one. Thank you, Steve and Lisa. My question today is, when trying to patent my product that uses a already patented item in my idea, reuse patent, using a already patented item for a different and unique use that does not seem to be utilized, how do I differ, or how do I refer to product? Like a tape that I use in my idea. Okay, I get it. Do I just use the patent number for the exact tape that is used?
Okay, I think I know what the question means. I think the questioner is asking, if I have a product that you're making that's new, but it incorporates something that's already patented, what do you do? So the short answer is, it depends on how you got the product and incorporated it into your invention or your thing. If you purchase the product publicly and you pay, the public price for it, then it comes with rights to use that travel with the patent after purchase, or the patented item after purchase. Now that's different from licensing a product. So, software, for example, comes with licenses and comes with patents. Licenses will restrict uses and restrict other purposes. But assuming it's just a product that you purchase and you want to incorporate it into your invention or the thing you're selling, and you've paid market price for it, then you're okay. Now, if you're filing a patent application on your invention and it incorporates some other invention behind it, then I found that it's best to actually talk about what you're doing in the application itself and reference that thing in what's called the prior art section of the patent. And then the examiner, when they read it, becomes comfortable that you're not hiding the ball from them. And it really is a disarming event for them. And I think it makes it more likely that you get a patent.
Interesting. So do you think that's being too specific?
Do I think
in terms of writing claims, if you're getting a patent, so you talked about the commercial application. If I'm going to make it and sell this product, yes, I can reuse someone else's intellectual property as long as I've paid market price for it or bought it from the factory or whatever. Then I have permission, because that gives you use right, right? Because you bought it. So we understand that side. As far as the patentability side, if I'm wanting to patent something that uses a tape, and more specifically a very certain kind of tape, do I want to name that tape in my patent application, or do I just want to say generally?
Yeah, I wouldn't name the brand, but
the number.
Yeah, but I might cite it. Actually, I might cite it by a patent number. Or I might cite it by a patent application number in what's called the prior art section of the patent application. And then when I get to the description of my invention, uh, I wouldn't mention what you have at all, or what you're incorporating at all. Just talk about your invention. Don't worry about what else is there because you've already talked about it earlier. Now, when you write claims, there's actually two answers. There's an answer in the United States, and then there's an answer in pretty much the rest of the world, especially Europe. So in the United States, when your attorney writes your patent claim, it will be just your invention. It's just a description of what you have. Mm-hmm. In Europe, there is the practice of two parts to a claim. The first part to the claim discusses really the prior art. And then your claim says, here are the magic words, comprising the improvement of, and then you describe what you're adding to it. So depending on where you are in the patent office you're using, there are a couple of different approaches, and your attorney will understand the nuances involved with that.
So interesting comment, not really a question here though, from Jay Bradley here. He says, thank you for addressing this. I'm always warning people about it. I file a provisional, either the same or updated every 2 or 3 months. What do you think about that strategy?
Yeah, so this is a strategy I use with some of my clients, some of my larger clients. We have invention disclosure meetings every 2 or 3 months, and following the meeting, we file one or more provisionals, and then when we meet again in another 3 or 4 months or 2 months, we file more provisionals, and then we keep track of when we filed the earliest provisional on a particular idea, and then I work with the client to make the decision: do we file for the utility, before that 1-year expiration date is up, or are we letting that original idea go? So what I see happen again, this is in a business context, is that the earliest provisional often does a little more than identify the problem and have, square blocks that describe a solution. But sometimes that's enough. But if it's not, there's not a huge risk with letting it go necessarily. But once that application that's a provisional starts feeling like, hey, this is going to be something, that's a deadline I watch like a hawk, and I don't let 1 year past that go without really grabbing the client by the collar and saying, hey,
And this is based on filing fast to get that initial stamp and then continuing to iterate, because we know it takes V1, V5, V10, sometimes V20 version is what I mean by V, for those of you who are unfamiliar with the term. You go through multiple iterations when you're inventing. I've never, ever seen the first idea be the best idea. Even my very first product, the French Twister, purely by accident. I wanted to make it out of wire with foam around it that, came around your hair and rolled up and made a French twist, but I couldn't figure out how to manufacture it. So I ended up going to a manufacturer. The only thing I could find in the yellow pages, because we didn't have the internet back then, was a plastics injection molder type of manufacturer. And so we chicken scratched it on paper together and just said, well, what if it just had teeth that came together and it was a plastic piece? If I had filed a provisional on the first one, I would have had to just abandon it and file a provisional on the other. And it would have had to be a new date anyway, because they were completely different inventions. However, if it was an iteration on that foam concept, I could have followed the strategy that you were just laying out and that Jay was mentioning earlier.
Yeah, and there's something else to consider on a provisional when you're taking this particular strategy. And if you don't have a really tight budget, sometimes what you'll do is, as you're developing a product over a year, you'll see a better way to engineer it, and you'll see, hey, I want to take the invention down this path, call it B, and let's say that what you thought originally was path A. and you get to the point where you're ready to file your utility within that year, and it hits you that, well, I like B better, but I certainly don't want one of my competitors to be selling A. And so
Mhm.
maybe I need to file a patent on
Like
both
that
of
anyway,
those.
just to keep them away from it. That's
Yeah.
what it taught me 15, oh, 12, what am I saying? Over 20 years ago, we want to build a fence around this as far as we can and even if we're only going to use this use case, we still want as much protection even on the bad stuff around it to keep
Yeah,
them.
because what you're protecting isn't just your invention, it's the space on the shelf at the store
That you're
around your
looking for.
invention.
Yeah, exactly. That's awesome. Okay, back to our questions here. Stefan says, am I right in believing one advantage of a provisional is that you can include several ideas for one product at once, even if some of them might be unpatentable? You may need to replace the provisional with multiple non-provisionals. Is that correct?
Yeah, so this is sometimes called the cookbook approach, where you just take everything that was on your mind on a particular date, you throw it into a provisional, and you send it in. Like everything else, that has pluses and minuses. So, one of the pluses is you save money because you don't have to file multiple provisionals. One of the minuses is that once one of the patents that is based on that provisional uh, publishes, that provisional can be accessed by the public, by someone who knows how to do it. And then you might have things that were in that original provisional that you don't want to be publicly disclosed. This used to be, well, I say used to be, it still is a problem or could be a problem. Uh, I saw someone make a mistake once where they took a business plan and filed it as a provisional. The business plan included information about their invention in it. Well, once their patent eventually issued, everything in that business plan became public. Their suppliers, their go-to-market plan, some of their
Wow.
comments about their competitors and how to deal with them.
Wow.
Yeah.
Why would they do
So,
that?
yeah. So you do want to be careful about what you put into a provisional. Well, the old rule used to be that provisionals never published,
Right.
but and they don't publish on their own accord, but they became accessible a few years ago, and this is something that trapped someone um, between the changes in those rules. By the way, that at the risk of getting on a soapbox, that's one of my pet peeves is that you will file for a patent application under one set of rules and expectations, and then the rules change, and you lose the benefits that you had before. But
And for the record, for those of you who may be just tuning in, Steve is a longtime friend and one of my patent attorneys, someone that I've worked with on all of my very successful products. And he is not taking new clients. He's doing this and here as a favor to me. He works primarily with large organizations. He has been kind enough to post his own email address here. Steve, when can and should someone reach out to you?
well, in particular for patents, if they have a business that's doing, at a minimum 500,000 a month in revenue, then that's the kind of business that,
Yeah.
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 If they're independent inventors and they want a referral to an attorney I trust, they can reach out to me, but I probably won't be working on your matter. If they have an online business with trademarks and copyrights, I have a systemized program for helping online entrepreneurs. So you'll get my attention for a while, but then I pass that off to an associate who does most of the, I call it grunt work, the filing of the stuff. But that is one way to get in touch with me.
And Steve does have some really great tutorials, free tutorials that you can check out. If you want to go to his YouTube channel, go to YouTube and just search trademarks and patents for growing businesses. And you can watch some of those free tutorials. I'll leave that up for a moment. I'm going to go back to questions here. I saw, oh, by the way, Chep says, yes, thanks. That's what I needed. So we answered his question. Glad to know. Thanks for the feedback, Chep. Christopher says, have you ever had a company interested in a product of yours and ask if you had any protection? And then you quickly file a PPA because they asked the question. Thank you. I love the question, Chris. Thank you. I don't know,
Lisa.
I mean, you're an inventor also. You have your own patents. What's your experience been? I'll jump into that, but I want to hear yours first.
Well, my first rule is don't lie. But
because they're going to find out you
they're
lied.
going to find out. You know,
submit the paperwork. Yeah.
Yeah. You know, the one wiggle that you might have is if they ask you the question and you file for a provisional the same day, then technically it was effective at midnight the night before. But I will tell you a story about a trap that I saw someone fall into who did something like that back in actually about the time Lisa and I met. I worked at a much larger law firm back then, and we got a call from a company down in Austin, and they had a new and innovative product they had shown at a trade show, and a private equity firm had come in and offered them on the spot to, start due diligence for acquisition as a real estate product. And during their discussions at their trade show, they said that they had patents, they said that they had copyrights, they said that they had all this stuff protected and wrapped up. Because of the content or because of the context, you're guessing probably right that they had nothing. And in fact, none of us had ever heard of them before. They left the trade show and then they came to the law firm.
Wow.
And because they didn't have copyrights, because they didn't have patent applications, they didn't even have provisionals. And in fact, they had done most of their development with student employees or student contractors from the University of Texas, but they didn't even have contractor agreements with most of them.
Gosh.
Some of them were overseas. During what's called due diligence, which is where companies take a look at what you have to make sure that it meets the representations you've made. The acquisition price that they were discussing went from over $25 million down to, I probably can't publicly disclose, and it did sell, but let's say that it was a tiny fraction of that number.
Right.
It went from making the financial decision that's generational wealth to basically, a nice car.
Why does it make a difference to the company when you filed it?
Well, in their case, they had not filed anything. And so, for example, with copyrights, if you wait more than 3 months after a public disclosure, you begin to lose rights under copyright law, such as rights to preliminary injunctions, rights to what are called statutory damages, rights to recover attorney's fees, things like that. You'll hear people say that you can always file a copyright, which is technically true, but the rights that you get from a copyright application that's filed, say, 5 years after you've gone through a publication are, like eating a peanut and calling it dinner. Whereas if you file quickly, you have many more rights. With a patent application, obviously, as we were discussing earlier, if you wait to file after you've made a public disclosure or offer to sell, especially more than a year, your ability to protect your invention goes to nothing. And you're also at risk for what other people have done within that year. Right. So, and not to mention the loss of trust that occurs and respect in a transaction like that, because when a company is looking to get your product, they aren't just wanting to pay you so they can take your product and put it on a shelf. They're probably looking for you to help promote it, to help them brainstorm about ways to bring it out. If they can't trust you, you've just greatly diminished the value of what you bring to the table. Absolutely. Beyond that invention.
Absolutely. And remember that there's an exception to every rule. I don't even think what's even to say right now is absolutely a rule, but it is a fact. The flip side of that fact is also, for example, with scuncie, I know for a fact that the inventor of the original scrunchie was called a scuncie. And that day, unbeknownst to them, not only did they get a license deal on the product, but the owner of scuncie which was called L&N Sales at the time, said, we love this name too, and we're looking for a brand name. Can we license the name as well? And they said yes. And then her attorney went that day to file the trademark because they didn't even have a trademark on it. So, and technically, I don't even know because I don't know how long she'd been using the name. There could have someone else really wanted to stop that brand or cause a lot of trouble for Conair. There probably is some history there they could.
Yeah, trademark reservation is a completely different topic, right? Yeah. So with patents and copyrights, the idea behind those systems is to encourage people to invent and create. And so all the rewards are based around the thing you've created, or the book you've written, the video you produced, the software you wrote, whatever. With trademarks, those are viewed more properly as a stewardship right you hold for the benefit of the public, so that they don't become confused about products that they're purchasing. And so if you're not actually selling a product or service, or have a company that does, you're not entitled to that brand name or that logo
at that point anymore.
Yeah. So go ahead.
I was just saying, I don't want to get too far out into the weeds on trademarks, because I know right now too, you're really focusing a lot more on trademarks and copyrights these days. Yes.
Yeah. And part of the reason is because patents have been, I don't want to say destroyed, but they've been, the rights that you get with a patent have been harmed over the last couple of decades. I mean, they still exist. They're still powerful.
So Chris, I'm sorry, Steve.
I was just going to say, at one time, patents were so powerful that to even, waste time talking about copyrights and trademarks in the context of an inventor, it was just the sideshow. Now you have to consider the whole thing you're bringing to market. It's now not merely, that.
It's the macro, yeah.
Mm-hmm.
Macro approach instead of the micro. So Chris, the only thing that I would add to what Steve said from a licensing perspective is you really shouldn't be reaching out to companies if you're not at least patent pending. There was a time before PPAs existed that just signing an NDA, you wouldn't file a utility necessarily. They're very expensive. So if you wanted to talk to companies, you could get an NDA, which still gave you the right, but you ran a bigger risk of someone knocking you off. So the USPTO created the provisional patent application, which only costs $75 for someone who fits the criteria to file. And you fast, easy, get it filed, and then at least you can start talking to companies and do some of the other strategies around whether to refile or iterate and all of that we've talked about prior. So I hope that helps answer your question. If not, feel free to clarify a little bit more in the comments below. Jay, I don't know what you're saying OMG about, but I'd love to know if you want to drop that in the comments. Stefan, thank you. Good advice on the cookbook approach. Dave, I'm not sure what you mean by that, but I'm going to leave names out of it. Okay, Sarah, here goes. Hello, Ms. Lisa and Mr. Brad. It's Steve. Thank you both for all the valuable information. Well, thank you for being here, Sarah. I went the provisional route with my products, which gives me some peace of mind while I'm reaching out to companies for licensing consideration. My question is that even though I have the provisional and I know my information is protected, is it overkill to ask companies to sign an NDA? I've heard that it is a good idea to have companies sign one, and I have also heard it doesn't matter. I'm so glad you asked that question, Sarah. Very common. Steve?
NDAs are art, not science.
That's a good way to put it.
Yeah. So the most common question I get around NDAs is, hey, can you send me your NDA form? And the reality is I have about a dozen different kinds of NDAs. based on the nature of what the inventor is disclosing, based on the nature of the company that's receiving it, based on the level of trust between the parties and what the goal is of having the NDA. So, let's just generalize here. Is it better to have an NDA than not? Of course. And in fact, when you're trying to make a case that you have a trade secret, one of the requirements is what you have must actually be secret. Well, a defense attorney will look at the disclosures you've made, and any disclosure made without an NDA in place is or a privilege. So, if you say something to a spouse or a business partner, that's fine. But if you don't have either an NDA or a privilege or some other kind of special relationship, like a fiduciary relationship, that information could be attacked as no longer being a trade secret. So having even just a very thin NDA can be very helpful. Now, part of the art also is not turning off the company that you're sending information to. You want to look like a pro, but you don't want to look like a jerk. And so sending a 6-page non-compete disguised as an NDA will turn off the companies and they'll show you the door, or if they respond at all. But the best way to deal with it, I think, is to map out, work with Lisa to plan how you're going to approach each company that you want to license to, and decide what you're willing to discuss. So if something's already public information, why hide it? Why put somebody through an NDA with it anyway? But there's going to come this line where you're going to start feeling really uncomfortable going any further. That's where you start talking about an NDA. And in fact, you might even consider couching the process as having a preliminary NDA and then a formal NDA once more detailed discussions begin.
Right.
So there's a right way to do it, but it is an art. And so that's one of the big values that Lisa brings to the table is, she understands how to do this.
Thank you. And no, I did not pay him to say that. I think understanding the why behind all of these questions helps you understand then the principle for when and how to use the tools that are in your tool bag, an NDA, a PPA in these examples, right? So why do you need an NDA? Why is it important to you would be my question if we were in a coaching session. And if it's insulation, because you just want to have a conversation as opposed to soliciting a license. I'm just looking for feedback from this company, when in reality, you hope that it leads to licensing, but that's the initial conversation. Well, if you don't want that clock to start that we talked about earlier, then an NDA keeps it confidential to have a conversation, not a solicitation about your invention, so that you don't have the issues that we talked about earlier. So the why behind you needing it or wanting it will help answer that question for yourself of when to use it and when it's not important for you. That's why you're hearing both answers. Anybody who tries to answer any question about any inventing type of thing, unless it's their own personal story, there's a million answers. So that's why the context and really having a conversation is going to be more helpful. I'd be happy to unpack that more for you, Sarah. If you want, you can go to the website that's listed here in the little ticker here that says theinventionaccelerator.com to book a free call. In fact, anybody can at any time. Be happy to get into that further, but I hope that answers your question. You're good. You got the PPA. You can talk to people. At least you know that you're in a position with some protection, some insulation to have those conversations for starters. All right. Awesome. Let me know if that doesn't answer your question. I'm happy to get into it further. We've still got a good 15 minutes left here today. Dr. George, thanks for taking my question. If a reputable potential licensee says they're interested in my idea and they offer what appears to be a good NDA to move forward, but their NDA is only for 12 months, is that something to be concerned about, or is that standard practice? Should one ask for a longer NDA, assuming you've already filed a PPA? It's a good question. Their questions are awesome today.
Yeah. So I would not have a time limit on an NDA. So a time limited NDA is typically only for business discussion purposes. So let's say that you're looking to uh, rent property, commercial property for your business. That's the kind of thing that you'll typically see a time limited NDA on. For something that's truly secret, something that's truly an invention, that NDA should not be subject to a time limit. But I will say this, there are exceptions that exist in common law to every NDA, such as public disclosures that, say a newspaper runs an article about the invention that a company has a NDA on. Well, that just invalidated their obligation to not talk about it, right?
Right. And if you're getting it licensed, then, and again, if we're talking about an NDA for your initial conversation with a prospective company, it is, your intention to license within those same 12 months anyway. You have to answer that question for yourself. Again, going to the why, understand the principle so you know how to make good business decisions for yourself. It doesn't matter to me if this is going to be shared in 12 months. That's the bigger question. And based on your circumstances and what the likelihood is of you getting it licensed, does that really matter? And then you can make a good business decision.
Yeah, I think you have to know what you're going to talk about.
Oh, that's a good point. Yeah, really clear.
Yeah, if and you have to know where that line is. I've watched inventors intend to discuss business, and sometimes they can't help themselves. They will literally open up their briefcase and pull out their invention, even when they've been told not to bring it to a meeting. Ask me how I know.
How do you know?
Know where your line is. Don't cross it. And especially if the NDA is only good for a year, then those discussions should be purely business and market limited.
Right on. And you can also help set the expectation for how quickly they need to make a decision. If they want you to sign an NDA that has a timestamp on it, then they better be prepared to come up with an answer and sign a check within a very relatively short amount of time, because that's shortening your window to now have conversations with additional companies.
Well, yeah. And once they sign it, let's say that they do insist on a 12-month NDA, then know what your lines are. And then if they say, well, you haven't discussed your invention with us, be ready and say, well, that's why I have this NDA for you to sign.
Right on. Yeah. This is what I'm willing to share with you under your terms. Under my terms, I'll share all of this, is what Steve's saying. Awesome. Really good advice. Okay. So Chris is just further qualifying on his question. In the example that we talked about earlier with the PPA, they ask about any protection by email. So company sends you an email and says, do you have any protection? You don't answer. You file your PPA first and then send them an email saying yes. Is that okay?
Well, yeah, I think that in that situation, sending them an email that says, well, why, yes, I have filed a provisional on this. Eventually, they're going to find out the day that it was filed. So I don't even think I would hide that.
Yeah, you don't even have to say the date. You could say, yeah, I just filed it.
Yeah.
We're good to go.
But you don't want people to be surprised. They're going to figure out what you've done at some point anyway.
Right. And it's okay that you file the same day. In most cases, that's not a problem. Just be upfront about it. Yeah, I happened to just file it. You don't even have to say that same day. I just filed it. But in general, you'll want to make sure you either have an NDA if you're doing really early discovery and trying to gain insights from companies about whether or not they might be interested in an idea that's still floating around in your head. So it's really, really early stage. You haven't even really invented anything yet. Then a PPA doesn't make sense. Obviously, if you have relationships with companies that you can talk to, an NDA, thorough one that is forever, like Steve was just talking about, without an expiration date. In that case, it's fine. But most people are kind of way further in the process and already filed a PPA, and they have their sell sheets and they fully fleshed out the invention by the time they start talking to companies, because they're not comfortable calling earlier. I love the idea of calling them first. I certainly do. That's what I try and do, but not everybody knows how or is comfortable doing that. Okay, boy, time is flying. We got about 10 minutes left, so let's see what we can do to get the rest of these answered. Nate asks, what are your favorite general IP knowledge websites and or books you recommend for inventors? Love it.
You know, the idea of a general IP website for an inventor outside of my own is scary because I don't know if you've ever heard of the Dunning-Kruger effect. So these two psychologists, Dunning and Kruger, did some studies back in the 1990s. And what they discovered was that when people have a little bit of knowledge, they tend to think they're experts at something. So, you know, they had this, and by the way, I'm sorry for the video because it's kind of going opposite what I'm trying to do. So, so when somebody's first learning something, they get to this point in their skill set where they think, oh man, I got this. This is easy. I'm an expert. And then the more they learn, and by the way, they call that the height amount stupid. And then the more they learn, they realize they don't know anything. And then they get to the point of the epiphany, which is realizing you don't know anything. And then you start to recover and get genuine competence. Yes. You know, I think anybody that's tried to do your own wiring or plumbing realizes that it was probably more than you expected when you first started. Intellectual properties like that. In fact, when I trained IP lawyers, and I used to train many at a large law firm I was at, I had what I called, and I would prepare them for the oh crap moment. That's the moment that they've been, you know, working and being paid, usually a lot of money full time for about 8 months to a year and a half. And they realize they don't really understand anything. That's for IP professionals. And so, and in fact, I went to law school because I was a frustrated inventor and I couldn't get my head around the patent law. And even after I graduated, and that was what I was trying to learn. I had only yay much. So, you know, I wouldn't suggest anybody just kind of generally, you know, try to pick up on particle physics and go out and claim that you know it well enough to explain how to do it on your own. Same thing for patent law. It's just chaos. You mentioned NOLO books. I mean, if you don't mind reading books on law that are longer than the Bible, sure. And they have some pretty decent information in them. And in fact, I think for attorneys that are patent practitioners, trademark and copyright practitioners, they can be some decent, quick first impression resource guides. I will tell you, I've read just about all of them related to IP, and about every 5 or 6 pages, I'll read something and go, I don't really agree with that. So, you know,
I'm just going to jump in and say, I think in my experience, and I've been doing this for 30 years, Steve has been one of the deepest wells of information for me. And like I said, he has a way of, now we spent we spent probably hundreds of hours talking. So I understand his language. But if you go to his website or his YouTube channel, there are a lot of free videos. I think that's probably, in my opinion, the best place to start. And then maybe just follow up with an email with Steve. You go to YouTube and put in trademarks and patents for growing businesses, like it says here.
Yeah. By the way, on the note of good websites, good books, I'm currently working on a book on trademark law where I take the words that the trademark office uses and I translate them into plain English. And I think that's part of the problem I'm trying to explain, is that if you read a website about IP law, you're going to be reading about concepts and things that in the world of patent and trademark law mean one thing,
right?
And in normal human speak means something completely different.
Right.
I'll just give you one example. There's something called a final office action. And when you receive a final office action as an inventor, you're probably going to have one of those oh crap moments. I'm dead. I'm done. There's nothing else to do. What you learn as a patent practitioner and as an experienced inventor is that a final office action is really any office action other than the first one you get. And the way to respond to a final is to ask for the patent office to continue examining it. And by rule, they always have to say yes. So there are these words that can really throw you off. You know, let me tell you what, if you send me an email, I saw that you're a professional engineer. I'll send you a link to a few sites, but I don't want to drop them into a general conversation with folks that just aren't going to be as
it'll just complicate things much too much. Yeah.
Yeah.
That's nice. Thank you for offering to do that. Dr. George says, thank you. Great info, Steve, by the way. Let's just pop this up here. Dave asks, what if your product is complex but unpatentable? Is it a viable strategy to out-invent the pirates to keep on introducing clever and new features that they can't keep up with?
Well, that's just marketing. That's just the marketplace, right? Is it a viable strategy? Heck yeah. I mean,
yep.
There are a lot of people that got rich, doing things like this.
That's what the companies that you mentioned earlier who knock you off when we were talking about getting knocked off. That's what they're doing. They're designing around, and they're usually not even filing patents. So for example, with TC Pets, the one I was on Shark Tank with, I got quote unquote knocked off. But the reality is to just put pockets in a stuffed animal versus compartments like I had with foam that were shaped and molded. They were able to work around my patent and just stick with public domain. And at the end of the day, it didn't matter. They went in, they took what they could from the market, sold as much as they could, and then got out.
Yeah. So something that the knockoff pirates do is they actually work from the marketing backwards. They will work with the marketer, and they will work with maybe a group of test consumers, and they'll listen for the features they want. They'll put them in the advertising, and then they'll figure out how to get the feature into the product, even if it's, through the cheesiest thing you've ever seen. So they frequently take that. Yeah. Right? Yeah.
It's an interesting question. I'm glad you asked it. Okay. Looks like we're just about out of time. We have time for one more here. Jay asks, at the end of 12-month NDA, is it considered public disclosure of the information?
Insofar as you've disclosed things under that NDA. Well, okay. So
if let's assume someone filed a PPA and did nothing, didn't talk to anybody, didn't go to trade shows, whatever, at the end of 12 months, does it become public because it was filed? Does it become public disclosure with the USPTO?
Yeah. So the answer is maybe. and
just want a direct answer here.
Yeah. Well, there's so many cases that deal with this, because this is at that line, right?
Right.
So when you change just like one or two little facts, it changes everything. It depends on if there are other duties to keep things disclosed. It depends on whether you mean a public disclosure for purposes of trade secret law, or do you mean public disclosure under purposes of the patent statute?
Okay, so let's assume for patents. I see what you're saying. I forget there's a lot of IP guys. There's patents, copyrights, and trademarks. We're just talking about. We'll take this question in the context of patents.
Designs. Yeah.
Let's take this question in the context of patents. And Jay, you let me know if you need it in some other context. But in the context of a NDA, is it public disclosure at the end? I'm sorry, at the end of 12 months, is it considered public disclosure?
Again, that's hard to say. Every situation is going to be different. I think that my instincts on what the default would be is that it's a disclosure insofar as you actually disclose stuff. If you said, I have a black box and it cures COVID, well, that would be a disclosure that you're claiming a fact, not of how you do it.
But
Right.
even if Jay didn't do anything at the end of the 12 months, that company now has the right to disclose it. And it intrinsically, at that point,
Well,
starts that clock as
yeah,
well.
it's this trade secret issue we talked about earlier. So when I'm doing a seminar, I'll draw literally walls. So I'm drawing what looks like a medieval keep, and each wall is a different relationship or contract that's used to keep an obligation secret. If one of those walls disappears, that thing just became not
The
secret.
veil is gone, right?
That's right.
Or the veil. Okay, Jay, I hope that answered your question. We're out of time, but I'm glad we got it in right under the line. If you need more details, you can certainly drop it either in the comments here, even after the show. As I mentioned before, this is being recorded. We're here every Wednesday, health and God willing. And I never tell anyone who my guests are going to be. So if you want to be notified, you can go to the inventionaccelerator.com and sign up or book a free call with me at any time. Steve, thank you so much for volunteering your time to help me educate inventors.
You're very welcome, Lisa. It's been a pleasure.
All right. In the meantime, you all have a wonderful week. Happy New Year, everyone.
Some great questions.
Yeah, really good questions today. Thanks for all your participation. Happy New Year. See you next
Happy
week.
New Year.